morning, good afternoon, sorry, and welcome to our webinar Planning Ahead with Lasting Powers of Attorney, hosted by Athena Care Homes and delivered by the brilliant team at Ashtons Legal. My name's Lisa, I'm part of the regional team at Athena Care Homes, and I'm hosting the webinar today. This webinar is being recorded and we can send you the link afterwards, so if you want to follow up with anything that's been said, you can re-watch. Please can I ask that you mute your microphones, turn your cameras off. If you've got any questions, use the chat box function and we'll raise them with the Ashtons team at the end. So without further ado, I'll hand over to the Ashtons team to introduce themselves and I'll put my microphone on mute. Okay, thanks guys.
Good morning, everybody. My name is Patricia Gray from Ashtons Legal Solicitors. I am a senior paralegal in the Lifetime Planning Department. I work closely with Lynn Wicks, who is joined today, who I'm joining today, who is a partner in the department. Our role, amongst other things, is lasting powers of attorney, which we have come to speak to you today about. We're not sure how well versed people are about lasting powers of attorney, but if wills are important after death, then lasting powers of attorney are certainly just as important while someone is still alive. We're presenting the slideshow, and as Lisa said, please raise questions via your chat box, or if you would prefer to ask questions in person at the end, Lynn is happy to do a Q&A session. We'll start with the first slide, which is what are lasting powers of attorney? Now that's Lynn and I, the Rogues Gallery, and there's lasting powers of attorney. So what are lasting powers of attorney? They're a legal document you can set up to authorise someone else, the attorney or attorneys, to manage your financial or personal affairs on your behalf. There are two types of lasting powers of attorney: property and financial affairs and health and welfare. Property and financial affairs deals only with your money and your property, so it's pretty much what's on the tin. Health and welfare is purely about your health and your welfare. The difference between the two is, one is the property and financial affairs can be in use immediately. It's registered at the Office of the Public Guardian. So if you're healthy and well and still have capacity or not, those can be used. The health and welfare lasting power of attorney can only be used once capacity has been lost or is certainly failing. I will now pass over to Lynn Wicks, who is going to go through the next slide with you and the subsequent slides to go into more detail regarding lasting powers of attorney. Lynn.
Right, good morning everybody. Right, as Patricia has mentioned, the lasting powers of attorney, they are a legal document and they are a bit like insurance, hence the picture. You know, you don't know if you're going to need them, but if you do, they are invaluable in making sure that your finances or your health and welfare decisions can be carried out seamlessly by your nominated attorneys. So the person that's making the power of attorney, that's what we call the donor. They will be appointing attorneys, and you can appoint just one attorney, but it is usually sensible and advisable to appoint at least two. Or if you only have one person in mind that you want to appoint, then think about who might be a replacement if your nominated attorney can't act for any reason. The certificate provider, that's the person that's actually going to confirm in the document that you are of sound mind and you know what a power of attorney is and what you're doing. It's just a bit of a safety check. And once everybody has completed the power of attorney, it is sent off to the Office of the Public Guardian. That's the administration arm of the Court of Protection. And there's a process to be gone through that we'll talk about to get the power of attorney registered and ready for use. So the Property and Financial Affairs LPA, as it suggests, enables your appointed attorney or attorneys to manage your bank accounts, to pay your bills, make any decisions about your investments, and of course, if you own a property, to sell or rent your property. So basically, they can do anything financial that you could do yourself as the donor. The Health and Welfare Lasting Power of Attorney, that is a very similar document, similar length, similar process, but it enables your attorney or attorneys to make decisions about where you live, who might visit you, the type of care that you might receive, if you're going to have a medical operation, or any other day-to-day routine decisions about your health and welfare. Now, your attorneys under the Health and Welfare Power of Attorney can only make those decisions if you don't have the requisite capacity to make a particular decision about your health and welfare. When thinking about making a power of attorney, there are factors that we would discuss with you just to have a think about to make sure that the people you're appointing as your attorneys are indeed sort of the sensible people to appoint. So we usually explore with you your family, you know, who in the family do you trust? You might trust them all, but perhaps one child or relative is better with finances or is better with making health and welfare decisions. Maybe in the medical profession, they might seem the obvious choice for that. So you don't have to appoint the same attorneys for both the Financial and Property LPA and the Health and Welfare LPA. Another potential complicating factor is whether you've got jointly owned property. So a lot of people own their homes with their husband or wife, and that can have implications further down the line if the property is being sold, but we'll come on to that a bit later in the talk. Business interests, if someone's got business interests, then it might be appropriate to do a separate financial and property lasting power of attorney specifically to deal with the business. So there might be someone that's in the business that's familiar with the workings of the business that would perhaps make more sense to be appointed than a lasting power of attorney to deal with your personal finances. As far as foreign property is concerned, the lasting powers of attorney generally only have jurisdiction in the UK. There can be some sort of leeway between the foreign countries. It depends which country it is. So when making a power of attorney, we usually explore if someone owns assets in another country and whether the power of attorney is likely to be sufficient or whether you need to get legal advice specifically for that country. And complex investments, when drafting the powers of attorney, there are particular clauses that can be inserted to make the powers of attorney more bespoke, and certainly complex investments is one where we would look at bespoking the power of attorney. Right, so if I talk to you now about actually setting up the lasting powers of attorney. So as I've indicated, you can appoint one or more people to be your attorneys. Think about if they are sensible to be appointed, and actually ask them, do they want to be appointed? Acting as an attorney can be quite time consuming and onerous. So it's best that, you know, acting as attorney is not a surprise to them. And replacement attorneys, not for everybody. Some people like to put all their children in, but others, you know, have got one child particular and they would put the others in as replacements. So it's all things to explore as to who you're going to appoint and how you're going to appoint them. So I probably ought to explain about how attorneys can make decisions. So you can either say that your attorneys can make decisions jointly and severally, which means they can act together in making a decision, or they can act alone. So that's why it's important that you trust your attorneys implicitly. The alternative is to appoint your attorneys to act jointly, The difficulty with that is that the attorneys have to make all decisions together and unanimously. So you might feel, well, my attorneys that I want to appoint, they get on really well, they're like-minded, and I feel sure that, you know, they would make joint decisions very well. The difficulty is that if you appoint attorneys jointly, and then one of those attorneys dies, becomes bankrupt, then that power is useless because the remaining attorney cannot carry on acting. So it is better and more flexible if you appoint your attorneys to act jointly and severally. And as I said, they can then decide which decisions either of them are going to make and whether they're going to act, you know, together. It just gives a bit more flexibility and makes the power of attorney sort of with more longevity. Now, when can your attorneys act? With a property financial power of attorney and dealing with finances, your attorneys can act as soon as the document has been registered at the Court of Protection. With the health and welfare power of attorney, they can only act when you've lost capacity. It's quite difficult for people to understand, well, you know, what does that mean? So capacity is subjective, and it will depend on the day, the week, person's medical well-being at that time as to whether the attorneys need to step in or not. So it's sort of a continuous judgment call. The other main difference with the health and welfare power of attorney, other than that the attorneys can only act when you've lost capacity, is the ability to give your attorneys the power to make life-sustaining treatment decisions. So there's a separate section in the form, and as donor, you can say whether you want your attorneys to be in the driving seat and able to make life-sustaining treatment decisions, or whether you would prefer the professionals, the medics or social services, to be making that decision about life-sustaining treatment. Acting as an attorney, as I said, can be quite time-consuming and onerous, and there are guidance and instructions for attorneys that you can put in the powers of attorney to make them more bespoke to you. If you don't, then there are sort of legal requirements that the attorneys must follow in carrying out their duties. So who can be an attorney or a replacement attorney? You've got to be an adult, got to be over 18. In relation to the finance and property power of attorney, your attorney cannot be bankrupt. As I mentioned, you need to trust them implicitly, and you know, I would say it's a good requirement that they are good at managing their own monies if it's in relation to the finance power of attorney. Usually it's family and friends that you appoint. In some cases, there aren't any family or friends that are willing and able or you feel are appropriate. So you can appoint a professional. Certainly as a firm, we do act as professional attorney for some clients, but only in relation to the finance and property power of attorney, not health and welfare, because we feel that's a bit too, you know, you've got to know the donor really, really well to be able to carry out the duties under the welfare power of attorney. I think that's probably it on that slide. Right, so this one I've already sort of indicated. So you can have a sole attorney, obviously, as you would think, appointing attorney to act on their own. You can have the attorneys to act jointly, which we've just shown as linking together because they have to make their decisions together and unanimously. Or you can have them joint and several. So you've appointed them together, but they can go off and do different parts of the role on their own and just report back to the others. If you've got, you know, concerns about certain aspects, it is possible to bespoke your power of attorney so that some decisions you are saying have to be joint, and some or the rest can be joint and several. The drafting of that is quite complicated, and if somebody was wanting to make that provision in their power of attorney, I would recommend that you get legal advice. Just reconfirming really that joint powers can be difficult to use, unanimous decisions, and if something happens to one of the attorneys, then the power is useless. Right, so this slide is just confirming for you that the lasting powers of attorney for the health and welfare can be activated as soon as it's been registered at the Office of the Public Guardian, or when you've lost mental capacity. Basically, the donor can decide at what point they feel that they want the attorneys to step in. Obviously, the power of attorney can only be used once it's been registered with the Office of the Public Guardian and not before. With the health and welfare power of attorney, it is slightly different. You have to have lost mental capacity, as I mentioned, but again, you can only use it once the power has been registered. Right, life-sustaining treatment decisions. So again, this slide is just confirming, do you want your attorneys or the doctors to make those decisions? It's a separate part of the form, as I said, and probably sort of 50% of my clients prefer their attorneys to be in the driving seat, and probably 50% prefer the doctors. Obviously, it can be a very distressing time, and you know, that you might feel that family would find it quite difficult to make the decision. It is possible to bespoke the powers of attorneys, as I said, and you can put in preferences, so guidance to your attorneys. I would probably say if you want to give any guidance, it might be better to put it in a separate letter, because obviously once the power of attorney has been signed by everybody, it is a legal document and you can't change it, whereas you might want to change your guidance or your wishes. So it is possible to put those down in a separate letter. Having said that, if there are any specific instructions, in order for them to be legally binding, you need to put those in the document. And again, I would suggest and recommend you get legal advice if that's the course of action that's required, because the Office of the Public Guardian and the Court Protection, they have been known to reject powers of attorney that have been submitted for registration because of the wording of such instructions. Right, so if we talk a bit now about the creation of lasting powers of attorney, they are quite a lengthy document and can look a bit overwhelming. They need to be signed by the person making the power of attorney, obviously, and be witnessed by an independent person. As I mentioned earlier, someone needs to act as a certificate provider. If you do your power of attorney through a professional, most professionals will act as a certificate provider. Otherwise, you might want to choose a GP or a consultant, anyone connected with your medical affairs, or you can actually have a neighbour or a friend, as long as they've known you for 2 years or more. I suppose the only caveat there is that the certificate provider is supposed to be checking that you understand what you're doing, and I just wonder how many next door neighbours, for example, would actually know the ins and outs of the powers of attorney to be able to act properly as a certificate provider. Ultimately, your attorneys also need to sign the document and have their signature witnessed. There is a strict order that the documents are completed, so it must be the donor signs first, then the certificate provider, and then the attorneys. And you do need to be very careful about the dates that people are signing. It does need to be shown that they're signing in the correct order. So once the power of attorney has been completed by everybody and it's dated and it looks great, it's sent off to the Office of the Public Guardian. Historically, it takes 8 to 10 weeks for registration. We are finding that in the recent times, it has been taking a bit longer for the powers of attorney to get through the Office of the Public Guardian. The registration fee, £82 per lasting power of attorney being registered. And I would suggest that once the power of attorney has been completed and has come back duly registered, that it's stored somewhere safe. If you need to take it to the bank, the building society, etc., if they want to keep it, keep a copy, I would recommend that you get solicitor certified copies, because obviously the original, if you hand it out, goes missing, then you've got a bit of a problem. Right, so some other things to think about. So the attorneys, they have some duties and responsibilities legally they must abide by, and it's not an acceptable excuse if an attorney does something wrong and they don't understand their duties. So it is perhaps important that once the power of attorney has been done and it's about to be activated, that the attorneys actually seek some legal advice on what they can and can't do, so they don't get themselves into a bit of mischief. And it's always better to be forewarned as what you can and can't do. You can't necessarily just carry on doing what the donor of the power historically did. So a classic example is about making gifts. The donor of the power may have been making gifts during their lifetime, but attorneys can't necessarily carry on doing that. Mental capacity. So mental capacity is the ability to make a specific decision at a specific time. It's subjective. So somebody might have the capacity to make a decision on one day but not on the next, or may be able to make a decision about something specific but not about something else. So it is very time specific and decision specific. Now everybody should be enabled to make their own decisions. So it might be that someone has a little bit of difficulty and they need a bit of help in understanding the process that needs to be gone through to make a decision. And somebody, can make an unwise decision, and other people around them might think, well, that's not a sensible decision. But as a donor, you can make unwise decisions. So assessing mental capacity can be quite difficult, and it does need to be, as I said earlier, it needs to be continuously thought about in relation to the health and welfare power of attorney. In relation to the financial power of attorney, it's perhaps not so onerous a thought process, because generally you can ask the donor, if you're acting as attorney, do you want me to pay your bills? And they might say, yes, please. And you can carry on doing that. And then there might be a decision about, do you want me to sell your house? And they say, yes, I want you to do that. So then you've got the authority. So it's, you're still going back to the donor to ask for their instructions, but not on such a regular basis, probably. Right, so the question about, what happens if there's no financial lasting power of attorney? Well, basically everything is frozen, because the donor is the only person able to access their finances, unless, of course, there's a joint person on the account. A husband or wife or a civil partner doesn't automatically have the right to access someone else's bank account, to sell their property, or to manage any of their investments. You might think that you're married to them, so why not? But no, you've got to have the lasting power of attorney for finances in place to enable anyone else to pick up your finances if you don't have capacity. if someone in your family doesn't have capacity, has lost capacity, hasn't made a financial LPA, it is possible to apply to the Court of Protection via the Office of the Public Guardian for a deputyship order. That's basically where someone applies to be appointed to manage finances, and the court will decide if the person applying is fit and proper, and they will issue an order to say yes, that person can manage the finances. But applying for deputyship is very time consuming. It takes 6 to 8 months, if not longer at the moment. And there's a lot more restrictions on what a deputy can do compared to an attorney. So it's always better to think about making a lasting power of attorney. Quite often we have family members saying that, mum or dad, they need to make a power of attorney, but they've had a diagnosis of dementia or their capacity is not great. The capacity required to make a lasting power of attorney is different to the capacity required to manage your finances and to make other decisions. So it's always worth speaking to a medical professional or a solicitor just to see if it is possible for loved one to make the power of attorney, even though they perhaps haven't got the capacity to manage the finances. As long as they can understand that they want to appoint X or X and Y, and it's to make decisions on behalf of their money, the fact they don't know how much they've got and they couldn't manage the finances themselves doesn't necessarily matter. So as I've indicated, the application to the Court of Protection, we were saying before the pandemic 6 to 8 months. It can take a lot longer, up to a year at the moment, unfortunately. It does require a mental capacity assessment to be carried out by a medical professional, and the court fee for applying for the deputyship order is £365, so obviously a lot more than the £82 for registering an LPA. And the ongoing costs and reporting requirements are quite onerous. The Office of Public Guardian will charge an annual fee for overseeing the deputy, and they will require an annual account to be completed. Whereas with attorneys, although it's advisable and highly recommended to keep the financial records as though you're dealing with your own finances, with the deputyship order, you are required to submit accounts, formal accounts, to the court. So a bit of comparison here on the timescale for doing LPAs. So 2 to 3 months perhaps to do an LPA under, pre-COVID, 6 to 8 months for the deputyship order. The costs, as you'll see, are a lot lighter for the power of attorney than the deputyship. We've put on this slide some of the sort of anticipated court costs, other costs, for example, getting the capacity assessment done, legal costs, the court fees, etc. So there is quite a hefty difference in going down the deputyship route. So for any client ringing up, we always try and get the power of attorney done rather than doing the deputyship. That's always a last resort. If there's no welfare lasting power of attorney, the people to actually make the decisions will be professionals. So it might be social services, it might be medical professionals. They will in effect be the decision maker. It is again not automatic, and a lot of people think, I'm husband, wife, I'm child, that I can make decisions about my loved one's health and welfare. That's not actually legally the case. If you want someone to be able to make such decisions for you, you do need to make a welfare lasting power of attorney. And I always sort of term it to clients as being in the driving seat. If you want family, friends, loved ones to be in the driving seat, do make a power of attorney for welfare. If you're not too concerned, or you haven't got anyone that you trust to make such decisions, then, you know, leave it with the professionals. If you do nothing and have no welfare power of attorney, the social service and the professionals will automatically step in. Any professional making a decision, or any attorney making a decision, has to make the decision in your best interest. So basically there has to be a consideration of your care needs, consult with any professionals that are involved in the giving of the care, and then what they call a best interest decision is made and recorded. It's very rare to actually apply to the court for a welfare deputyship. The court's view tends to be that if you want a health and welfare decision made about a particular person, that you have to keep going back to court for every decision. So obviously it's time consuming, very costly. It is possible to get urgent decisions through the court, but at the moment the urgent decisions are taking just as long as the normal. So it's not something to rely on, basically. Right, so in summary, there's 3 points to take away. They're like insurance policies. You don't know if you're going to need it. You don't know what's around the corner, but certainly if it's needed, it is well worth its weight in gold. Don't leave it too late to make a power of attorney. As I said, we do have clients that we sort of slipped under the wire because it was getting very, very near them losing capacity. But if you speak to a professional, they can probably guide you through if that's the case. And ultimately, the powers of attorney, they're very important and powerful legal documents, probably just as much as making a will. Right, so at Ashtons Legal, we do have quite a big team that deals with powers of attorney, wills, and care issues. You know, basically anything to do with you're not getting the local authority funding that you think, or, you know, is there eligibility for continuing healthcare? Something that a lot of people aren't necessarily fully up on. So if a loved one or you are in a care home, you know, we're quite able to offer advice on the whole spectrum. Right, so any questions? I think I saw some flicking up as I was talking.
Yeah, hi Lynn, I'll just read those back to you if that's okay. So we've got a couple from James. His first one is, have you got a worst case scenario of someone that doesn't have these documents in place, and he said they're in care, or they need to move into care? So have you got an example of a worst case scenario? Because I'm aware these things can drag on.
Yeah, I mean, there are scenarios, and there has been sort of in the press about, you know, if I think in this case it was a wife, she lost capacity, she didn't have any powers of attorney, and it was felt by social services that she wasn't safe living at home. The husband and the children wanted wife to live at home, but unfortunately they weren't able to persuade social services that was in her best interest. So obviously as a professional, they're independent, they will do all their assessments, they will speak to the family, and ultimately it's the family that have to persuade social services, who are in the driving seat making the best decision, that it is best for mum to be at home and not in a residential care. If family really don't agree with the decision made by social services, you know, you can challenge that, you can make a complaint, but ultimately you would have to go to court, the court protection, to make an application to say you object to the local authority's decision, and, you know, what you think your case is as to why that decision is wrong, and then the judge and the court will make the decision. So if you don't have the health and welfare power of attorney in place, you know, ultimately it will be professionals and somebody that doesn't know your loved one who's making those decisions and in the driving seat.
So basically the family have no automatic rights?
No. I mean, everyone thinks, so I'm next of kin. Legally, that doesn't really have any weight. You know, when you go into hospital, they will consult with family and they will ask who's next of kin, which is why people get confused. But legally, if it comes down to it, you have to waive a health and welfare lasting power of attorney in the face of the medics to be able to go to the case conference if they don't invite you, and to have the right to look at medical paperwork and make medical and welfare decisions. In the case of the financial power of attorney, I mean, it's the worst case scenario. It's obvious that, you know, money is frozen, you don't get access, and you know, if care needs to be paid, who's going to pay it? So it just makes things more complicated and complex at what is probably a distressing time when you really want things to move as smoothly as possible.
Yeah, okay, that's quite worrying. And I'd imagine there are a lot of people out there who aren't aware of these documents and how to use them and when they come into play.
Yeah, quite. I mean, most people know that they need to make a will. 2/3 of the adult population don't have an up-to-date will. And, you know, that's probably a worse scenario as far as powers of attorney are concerned. People just, you know, ignorance is bliss. People don't understand and aren't aware. So we do, and I certainly do, try and spread the word that, you know, they are invaluable documents. And certainly if clients come to us to make wills, we do tell people, you know, do think about the power of attorney. It's just as important as making a will. And I'm actually finding that again, as equally important is if you do make a power of attorney and you've appointed people to act for you, at the time they start acting, it's imperative they get some advice about what they can and can't do. I do sort out some terrible messes that attorneys have got themselves into, and legally, you know, it is a responsibility as attorney that you take on, that, you know, you can get yourself into hot water over.
Yeah, absolutely. Okay, that's great. He's asked, how long would a registration with the OPG take? I think we covered that, didn't we? Yeah, okay. And then in a care home, if someone's in a care home, who decides if someone has capacity to make decisions? So if there's no LPA in place.
Right, so if there's no LPA, then again, it will be back to social services. I would imagine that a social worker will get involved. The manager of the care home will be involved, and it will be the professionals caring for that person that will be in the driving seat, making best interest decisions. As I said, they will have a responsibility to consult family, but they don't have to agree and carry out the wishes of family if they don't want.
Okay, and I'd imagine, and this is a question from me actually, Lynn, over the past year or 18 months, you'll have seen some difficult decisions made around discharge from hospital, where people are going, mental capacity, rights to decide, that kind of thing. Is that quite the kind of thing you're dealing with at the moment?
We're seeing more and more inquiries coming through from existing clients or via the internet, you know, Google, etc. searches, where, I mean, it's a bit like an exam question. You get a family scenario and you've got to unpick it, and you know, going up against the local authority or the continuing health authority, and you know, in some cases we're finding that the clients have been told wrong, and of course, as the client, as the layperson, you know, you sort of take what the local authority, the social workers tell you and think, okay, but alarmingly, quite often they're not right, or they can be quite robust in what they're saying, which makes it quite difficult to challenge. So, you know, we're more than happy to advise people on their circumstances to say, well, actually, you've been told right, and actually, you know, there's nothing you can do, or, you know, it's on the right track. Or obviously, you know, if people have been told wrong, or we think they should be challenging decisions that have been made, we're quite happy to assist and pick up the baton to help with those challenges.
Absolutely, and it is, you're absolutely right. It's very difficult when you are in a quite often a highly emotive state. Your loved one is in hospital, very distressed. Maybe you've not seen them for a long time because of the COVID restrictions, and you've got a social worker saying, well, this is what's going to happen next. You're driven to believe them that this is the right information you're being given, but actually we shouldn't take that as gospel, that they've even got the right facts.
And also, as you said, it can be a very emotive subject, and because you're in the mix of it and you're involved personally, you obviously can be quite emotional, and sometimes to get the best out of social services or professionals, you need to be one step removed, and not throw every emotion in there, but be very factual. So it can help to have someone independent to be actually helping you to challenge what's being said.
And what's your area of specialism, Lynn? Do you work specifically with older people, or?
I work with older people, with vulnerable clients. I've got clients that have got mental health issues or physical disabilities, and I work with, I've got a couple of clients where they've got Down syndrome, and I help them. But in the same way, I've also advised the parents of those clients, because it needs looking at from both angles. So all mixture. I advise the client themselves. We advise attorneys, relatives. I mean, obviously we've got to be very clear when we take anyone on as to who we're acting for and in what capacity, and that there's no conflicts.
Yeah. Okay, that's great. That's perfect. Well, does anyone have any more questions? I see James said he's that's great. Thank you very much. I think you've answered all of his.
Excellent.
Any of the other attendees have any questions?
If anyone hasn't at the moment, but they think of any, they can always contact us. We're more than happy, myself or Patricia, just to have a quick chat on the phone. And sometimes you've got a couple of questions, and actually it's sort of, okay, we don't need to do anything for now legally, or we need to go off and find X and Y, and then we might come back. We're quite happy to be flexible, really, and if you want to pick up the phone, then please do.
Perfect. Okay, and I don't know if you can see the chat box, Lynn, but you've just had a message from Sarah.
Yes, hello Sarah. Long time no speak.
That's great, guys. Okay, well, it looks like everybody's happy. I'm certainly happy. It's been incredibly informative and really straightforward. I know it's a very complicated area to discuss, but the way you deliver it makes it really easy to understand. So thank you so much for that. And we'd love to invite you back later in the year to run another one of these webinars, if that's okay.
That'd be lovely.
Superb. Lovely. Well, everybody have a great day. Thank you very much for attending, and we'll see you all soon.
Thanks very much. Bye.
Okay. Bye.